Author Michael Wolff has claimed in a lawsuit that First Lady Melania Trump threatened to sue him for over $1 billion in damages if he didn't retract Jeffrey Epstein-related statements he made about her. Wolff said in the lawsuit that Melania Trump's threat to sue came over statements he made to the Daily Beast and in 3 videos published on social media, although he added some statements were incomplete phrases and were taken out of context. The lawsuit came on Tuesday, the deadline set by Melania Trump's lawyer for Wolff to retract statements, issue an apology, and pay damages to his client. Through his lawsuit, Wolff announced his intention to use the legal action to put the president and his wife under oath to answer questions about Epstein. Wolff conducted interviews with Epstein before his death. The lawsuit noted that Wolff never said Melania Trump was involved in any of Epstein's crimes. Among the statements the lawsuit said were true were those saying Melania Trump was very involved in Epstein's social circle where she met her future husband, and that it was fair to question how Melania Trump fits into the Epstein story.
Hey friends! Welcome. Adam is here, so what is happening right now, an authentic FBI interview summary, pulled directly from the newly released Epstein files, has just landed in the middle of Melania Trump's ongoing lawsuit against journalist Michael Wolff. Not a leak, not speculation. An official document stamped with federal law enforcement insignia, containing words so precise and so damaging that they've sent a shockwave through the courtroom. The narrative Melania spent years and millions constructing just cracked open.
I was notified the other day by Melania Trump's lawyers that they intend to sue me for $1 billion related to some of those statements. I'm not the first here. They have threatened and sued other people for saying similar things. These are called slap suits. They may have really no chance at all of proving defamation, but they sue anyway in order to intimidate you and really to shut down any discussion of the relationship of Melania Trump, Donald Trump, and Jeffrey Epstein.
Let me read you the essence of what that FBI agent typed into the official record. The document states, in language scrubbed clean of ambiguity, that Jeffrey Epstein personally introduced Melania Trump to Donald Trump. Not a business associate, not a vague social crossing, not a party planner whose name has been conveniently inserted into the timeline. Epstein. The same Jeffrey Epstein whose name Melania recently stood behind a White House podium to disown. The same predator she looked into the television cameras and claimed she barely recognized, barely knew, and certainly never considered a meaningful figure in her life story.
I never been friends with Epstein. Donald and I were invited to the same parties as Epstein from time to time, since overlapping in social circles is common in New York City and Palm Beach. To be clear, I never had a relationship with Epstein or his accomplice, Maxwell. My email reply to Maxwell cannot be categorized as anything more than casual correspondence. I am not Epstein's victim. Epstein did not introduce me to Donald Trump. I met my husband by chance at a New York City party in 1998. This initial encounter with my husband is documented in detail in my book, Melania.
That declaration, delivered with the full theatrical weight of the presidential mansion behind her, has now collided head-on with a government document that calls her a liar in the most clinical, bureaucratic language imaginable. If you have been riding with this channel through every twist of this saga, you already understand that we do not trade in hysteria. We follow the paper trail. We track the legal maneuvers. We read the filings. And today, every single evidentiary pathway converges on the same destination they have been pointing toward for months, straight into the epicenter of Melania Trump's secret history, and straight toward the question that Michael Wolff has been asking with a bullhorn while ducking billion-dollar legal threats. What exactly is she so desperate to bury, and why is she willing to torch the Constitution's free speech protections to keep it underground? To grasp the full magnitude of this FBI bombshell, you have to rewind to the genesis of this entire conflict. Michael Wolff is not some reckless blogger who stumbled into a story too big for his experience. He is the literary assassin who eviscerated the mystique of the Trump White House with Fire and Fury, a book that sold millions of copies and exposed the West Wing as a chaotic daycare center run by warring factions. Wolff has spent a career penetrating the innermost sanctums of power, and he writes what he finds with a merciless clarity that makes tyrants and first ladies deeply nauseous. When he pivoted his investigative lens toward Melania Trump and her entanglement with the Epstein network, he was not peddling gossip harvested from bitter ex-employees. He was applying the same forensic methodology that built his reputation, cultivating sources, securing documentation, asking dangerous questions, and reporting exactly what the evidence suggested, regardless of how many legal threats clogged his mailbox. And let there be no misunderstanding about the scale of those threats. The moment Wolff's reporting began connecting dots that Melania wanted to remain forever disconnected, her legal apparatus responded not with a reasoned rebuttal or a detailed denial, but with the heavy artillery of financial annihilation. This is the Melania playbook, refined over years of practice. When a journalist or a media institution gets too close to the Epstein truth, they receive a letter, not a polite request for a correction, but a cease and desist nuclear device threatening defamation damages so astronomical they would vaporize a corporate balance sheet. The Daily Mail received this treatment and ultimately capitulated, coughing up a settlement and a public apology to make the pain stop. The Daily Beast stared down the barrel of the same gun. Political commentators and book publishers found themselves targeted by the same legal machinery, all coordinated to send an unmistakable message. Mention Melania and Epstein in the same breath, and we will financially waterboard you until you gasp an apology. This is not the conduct of a person who is merely irritated by sloppy reporting. This is the behavioral signature of someone who is petrified of what a full excavation might unearth. So when Wolff published his findings and Melania's legal team predictably dispatched the same threatening correspondence they had used to silence lesser targets, they assumed he would calculate the cost-benefit ratio and quietly retreat into the shadows. They assumed catastrophically wrong. Wolff did not just tear up the letter. He transformed it into Exhibit A in a legal counteroffensive so audacious it likely made Melania's lawyers choke on their expensive espresso. Wolff sued her first. He marched into New York Supreme Court and filed a declaratory judgment action anchored in the state's anti-SLAPP legislation, those precious legal statutes engineered precisely to protect journalists and whistleblowers from the weaponized litigation that Melania's team had been deploying like cluster bombs. By seizing the initiative and filing first in a jurisdiction with the nation's most robust anti-SLAPP protections, Wolff executed a legal judo throw of breathtaking elegance. He converted Melania's billion-dollar threat into a judicial proceeding. He transmuted her intimidation into evidence, and he informed the First Lady of the United States, in language as formal as a wedding invitation, that he would not be silenced, he would not be bankrupted, and he would not stop asking questions. What happened next in the legal chess match reveals more about Melania's defensive fragility than any press release ever could. Once Wolff's lawsuit landed, her legal brain trust faced a binary choice. They could engage on the merits, argue that his reporting was factually false, and fight him in open court with evidence. Or they could execute the Trump family's signature legal tactic when the facts are radioactive. Obstruct, delay, and move the battlefield to friendlier terrain. They chose the second option with almost comical predictability. In the waning days of the previous year, Melania's lawyers approached the federal judiciary and requested that the case be ripped away from the New York State Court where Wolff had strategically planted it. This maneuver successfully transferred the proceedings to the United States District Court for the Southern District of New York, landing on the docket of a federal judge. This was not a neutral administrative shuffle. This was a surgical strike aimed at disemboweling Wolff's legal protections. New York State anti-SLAPP laws are a fortress for journalists. Federal anti-SLAPP provisions are a considerably leakier umbrella. By shifting the venue, Melania's team deliberately weakened the very legal shield Wolff had raised, and they did it knowing exactly what they were doing. But the procedural sabotage did not end there. Melania's legal battalion then advanced an argument so transparently absurd, it would be laughable if the stakes were not so grave. They claimed Melania had never been properly served with the lawsuit. Let the absurdity of that claim marinate. The First Lady of the United States, one of the most photographed human beings in the Western Hemisphere, a woman perpetually encircled by a Secret Service detail with the surveillance capabilities of a small nation-state, argued to a federal judge that nobody could find her to hand her legal papers. Wolff addressed this farce with the dry, surgical sarcasm it deserved. He noted that ambushing her on a public sidewalk was logistically impossible and that strolling into the White House to serve process was equally fantastical. The woman who has dispatched legal threats across multiple continents to silence her critics was suddenly, conveniently, a phantom who could not be located. This service dispute became yet another layer of delay, another procedural quagmire designed to exhaust Wolff's resources and patience before he ever got to ask a single question under oath. And then came the Florida Gambit, the most revealing strategic play of all. Not content with merely escaping the New York State anti-SLAPP regime, Melania's legal team pushed aggressively to transfer the entire case down to the Sunshine State, where she and the president maintain their official residence. On the surface, this sounds like a routine venue dispute, but context here is everything. Florida, in this particular legal landscape, carries a very specific implication. It raises the specter of the case landing before a judge appointed by Donald Trump. Not just any Trump appointee, but the possibility of drawing Judge Aileen Cannon, the very same jurist whose handling of the classified documents prosecution against Trump drew howls of criticism from legal ethicists across the ideological spectrum before she was ultimately removed from that matter. The notion that Melania's legal team was quietly engineering a pathway toward a Cannon courtroom is not a conspiracy fantasy. It is a cold, logical reading of a deliberate legal strategy. Wolff himself flagged this publicly, pointing directly at the Trump-appointed judge angle because he understood exactly what the Florida maneuver represented. It was not about geographic convenience. It was about shopping for the most favorable adjudicator available. Wolff has contested every square inch of this procedural battlefield. He filed a blistering opposition to the motion to dismiss while simultaneously moving to remand the entire case back to New York State Court, arguing that the removal to federal jurisdiction was legally defective from the moment it was executed. His position has remained granite solid throughout. This case belongs in New York, where the law is built to protect journalists from exactly the kind of legal bludgeoning Melania has deployed. Both motions are now fully briefed and resting on the judge's desk, awaiting a ruling that could reshape the entire architecture of the dispute. The case has survived. It has not been dismissed. It has not been exiled to Florida. It is alive, breathing, and radiating danger for the defendant. Then came the moment that changed everything again. Melania Trump walked into the grand foyer of the White House, positioned herself behind a lectern, and delivered a prepared statement to the nation about Jeffrey Epstein. She declared with rehearsed conviction that she was not his victim. She insisted that Epstein did not introduce her to Donald Trump. She characterized her proximity to Epstein as nothing more than the incidental overlap of social calendars, the kind of glancing contact anyone navigating elite circles in that era might have experienced. She branded her critics as morally bankrupt, ethically hollow, and engaged in vicious defamation. She called their reporting lies pure and simple. And then, without acknowledging a single question, without submitting to a single cross-examination, she turned on her heel and walked away. Now, if you possess even a rudimentary understanding of how the legal system operates, alarm bells are already shrieking in your head. Why would the First Lady of the United States stage a nationally televised press conference about an active federal lawsuit in which she is a named defendant? There exists a foundational legal doctrine called sub judice, which holds that parties to ongoing litigation must not make public declarations designed to prejudice the proceedings or influence the tribunal. The principle is sacrosanct. You do not try your case on cable news when it is actively being litigated before a judge. The courtroom is the arena, not the White House briefing room. Melania ignored this doctrine entirely and held the press conference anyway. Wolff's response was immediate, surgical, and devastating. He stated that her public remarks directly contradicted much of the evidence. Read that sentence again and absorb its legal weight. This is not a journalist waving his hands and calling her names. This is a plaintiff in an active federal lawsuit, a man who has reviewed the discovery materials and knows what his case file contains, telling the world on the record that the defendant just stood behind a presidential podium and said things that his evidence proves are false. He specified that her statement contradicts the known timeline and, most explosively, contradicts what Jeffrey Epstein himself directly said about her. This is Wolff signaling, with the confidence of a man holding a royal flush, that he possesses material, recordings, documents, witness statements, something that directly impeaches her public testimony. He is not guessing. He is informing the public that the defendant just perjured herself in the court of public opinion while an actual court case against her remains pending. But Wolff's analysis of why she held the press conference at all is where this narrative ascends to a level of political and legal drama rarely witnessed in American history. He offered several theories, each more damning than the last. His first and most legally incendiary theory is that the press conference was an attempt to influence the judge. He noted, pointedly and publicly, that the judge currently presiding over the case is a Trump appointee. The implication is staggering. Wolff is suggesting that the First Lady of the United States may have weaponized the White House podium to send a message to a federal judge with a pending decision in her case. If that theory is accurate, the press conference was not a public relations move. It was an attempt at judicial manipulation dressed in a designer suit. And Wolff connected this directly to the central thesis of his lawsuit, stating that intimidation is precisely what his case against her is about. In this reading, the press conference is not a defense against his claims. It is additional evidence supporting them. His second theory aligns with what crisis communication experts call getting ahead of the story. When you know a damning piece of information is about to detonate, you move first. You seize the narrative, you control the timing, and you inoculate the public so that when the bomb lands, it explodes in a context you have already poisoned. Wolff suggested that the press conference was precisely this, a preemptive strike, a signal flare indicating that Melania's camp knew something massive was coming and were racing to frame it before it arrived. If this theory holds, the White House address was not a confident assertion of innocence. It was a desperate evacuation warning. And then the FBI document surfaced, and suddenly Wolff's second theory looked less like speculation and more like prophecy. Because the document pulled from those 3 million Epstein files, dated from a federal interview conducted with a woman who served as Epstein's personal assistant, a woman who gave her testimony under a proffer agreement, meaning she was legally obligated to tell the truth under penalty of criminal prosecution, states explicitly in the words of an FBI special agent that Epstein introduced Melania Trump to Donald Trump, not as hearsay, not as tabloid innuendo, as a documented sworn witness account given to federal investigators during an active criminal investigation into one of the most monstrous sex trafficking operations in modern history. Melania stood behind the White House podium and told the world Epstein did not introduce her. The FBI document says he did. These two statements cannot peacefully coexist. One is the sworn testimony of a cooperating witness facing federal prison if she lied. The other is a scripted monologue delivered by a woman who has spent decades financially terrorizing anyone who dares to challenge her authorized biography. And then there is the Zampoli complication, which drags this story into even darker waters. Paolo Zampoli, the man who has publicly claimed credit for introducing Melania to Donald Trump, the man now serving as the president's own special envoy for global partnerships, is all over this FBI document in ways that should make every American deeply queasy. The document reveals that Zampoli had a romantic relationship with the witness. It reveals that Zampoli attempted to purchase a modeling agency jointly with Jeffrey Epstein, the very same agency that reportedly represented Trump's own daughter when she was a teenager. It reveals that Epstein was visiting Zampoli at that agency during casting calls for young models. The man whose testimony forms the entire alternative origin story for Melania, the chance encounter, the 1998 party, the "it was Zampoli not Epstein" narrative, was apparently in business negotiations with Epstein while scouting teenage models. That is the foundation Melania's entire defense rests upon, and the FBI document just reduced that foundation to rubble. Wolff has not publicly gloated. He does not need to. The sequence of events speaks with a thunder that no victory lap could amplify. Melania held a press conference denying everything. Wolff said her statement contradicted the evidence. The FBI document emerged and directly contradicted her statement. The document simultaneously incinerated the credibility of the man whose account anchors her alternative history. And the lawsuit that Melania's legal squadron has spent months trying to dismiss, transfer, delay, and strangle in procedural red tape is still sitting in federal court, alive and waiting. Every motion, every venue dispute, every claim of insufficient service has bought her time, but has not made the underlying facts disappear. The photographs still circulate. The social connections remain documented. The threatening letters are preserved in the public record. And now the FBI document exists, a government-generated evidentiary hydrogen bomb that no legal maneuver can defuse. Wolff's third theory about the press conference cuts deepest of all. He suggested, with the brutal candor of a man who genuinely no longer fears the consequences, that Melania simply loathes her husband, that Donald Trump is the architect of her current nightmare, that his world, his friendships, his extensively documented social intimacy with Epstein is what dragged her into proximity with the most toxic name in American jurisprudence. And that now, as Wolff frames it, Trump is doing things that threaten the Melania brand, the meticulously constructed public identity she has defended with near-industrial levels of legal aggression. Wolff's reading of the press conference is that it was not a defense of Melania at all. It was a message to Congress, an implicit signal that the man who got her into this deserves to be investigated, that she is exhausted from carrying the weight of his associations, that she used the White House podium to quietly, in the coded language of victimhood and dignity, point a trembling finger at her own husband. If Wolff is correct about even a fraction of that interpretation, what occurred at that White House podium was not a press conference. It was a moment unprecedented in the annals of the American presidency. A sitting First Lady using the most powerful platform on earth to signal to political adversaries that the man occupying the Oval Office deserves exactly the scrutiny she is currently receiving. That is not politics. That is a Shakespearean betrayal unfolding in real time before a global audience. We do not yet know how the judge will rule on the competing motions currently piled on her desk. We do not know whether the case remains in federal court or is remanded to the protective embrace of New York State. We do not know if the Florida transfer gambit will succeed or collapse under its own transparent cynicism. We do not know the full inventory of evidence Wolff claims to possess. We do not know what other horrors may still be entombed in those millions of unreviewed Epstein files. What we know is this: a journalist refused to be silenced. He sued the First Lady of the United States. She responded by holding a nationally televised press conference about an active federal case, and her opponent immediately declared she contradicted the evidence. Within days, an FBI document surfaced that validated everything Wolff has been saying, and the case is still breathing, still advancing through the judicial machinery, still carrying the potential to drag sworn testimony from people who have spent a lifetime ensuring certain questions were never asked in rooms where the answers could not be choreographed. Melania Trump has constructed her entire public existence on the premise that the story she tells about herself is the only story that matters, and that anyone who tells a different story will pay a catastrophic price. Michael Wolff looked at that price tag and refused to open his checkbook. The FBI document now suggests he was profoundly correct to do so. And whatever happens next, however this judge's ruling lands, wherever this case ultimately travels, the truth that Melania has spent a fortune trying to strangle in the dark is doing what truth always does in the end. It is clawing its way toward the light. Stay locked in, because when that judicial gavel drops, this channel will be the first to break down every syllable of what it means.